Hey y'all,
Hi, how are you?
I'm doing good, hun. Barely hit my goals, but I'm good to go.
Yay, that's good.
I'm excited.
Awesome, awesome. Okay, so I'm just for the sake of timing, I'm just gonna start it now and I'll be admitting people as they come in. Most of my friends are always late, so here we are. But okay, so thank you guys for coming in tonight. I'm really excited to kind of discuss something that has been honestly something that just keeps popping up in my professional career, which is probate as well as trust advisory. This real estate planning Zoom is made so that others will not fall into the cataclysm that can be probate in California. And so, typically when people try to navigate it on their own, it can be very challenging, especially during a tough time emotionally. So I feel that this is a really great way to help prepare for the unexpected and to really kind of take us there is Caroline Jenkins, who I met through, I believe it was April Campusuk initially. I'm still admitting people, so if I pause, it's because of that. But yes, and then we also are on the board of directors for ARIA San Diego. So Caroline, I will let you do a quick intro and then we can get into our PowerPoint.
Thank you. Thanks, Destiny. I'm so happy to be here tonight and to have people join us. And, maybe hopefully this isn't like your little sleep aid before you go to bed, this will put you guys all to sleep or something. That's why we're doing this at 6:30 at night.
Absolutely.
But I am a founding partner at Jenkins Jenkins. We focus on estate planning. That is what we do. We do trusts, wills, powers of attorney. So we do the planning on the front end, and we also do probate and trust administration on the back end, which is what happens when somebody passes away. I have been doing this for about 12 years now, and this is all that we do. It's because we love it. I fell into estate planning right out of law school, and I fell in love with it. And this is just what I continued to do. So there's a whole lot of passion behind it. We just love helping families, and I think that it shows. I think.
That's awesome. And so Michael is also on here right now. So shout out. So, okay, I'm just going to share my screen, you guys. Again, bear with me as I navigate this because I've never actually hosted a Zoom and presentation. So we're going to do my best right now. So I'm going to go ahead and click here and then do this. Ta-da! Oh my God. Yeah. I did it. Let's see. All right. And then we are on the wrong page. There we go. Let's start here.
It was just that first page. So we're just going to cover estate planning basics tonight. And in the next screen, we'll just see. So these are our topics. We're going to cover just what a will is, what is a trust, and powers of attorney. We'll cover what the probate process is and compare that with a trust administration process. And then finally, we'll kind of round it out with common misconceptions that some people have about estate planning. So we'll get started on the next slide. So what is a will? A will is, I think a lot of people know what a will is. It's a document that says, this is who is going to get my stuff when I have passed away. We refer to the things that are in our name personally. And I'll kind of touch on that a little bit more in the next slide. But for right now, a will is, we name the person that will take control over our assets. So if I'm not around, who's going to control my stuff and who gets it? But one big distinction I do want to make is that a will absolutely goes through probate. If a will is all that we have, it will be submitted to to probate court. And it's kind of like giving a judge written instructions as to our wishes. So we create a will, and some people think that we will avoid the probate process altogether. That is not the case. It's just we're going to go through probate, but at least we've kind of left the court a letter as to what we want to happen. If there isn't a will, so if we pass away without a will, the judge is going to decide who gets what and who is appointed to control our stuff. There is an order of priority as to who will control our stuff, whether that be a spouse, an adult child, parent, sibling. There is an order of priority, but sometimes it is whoever gets to court first. Just depends on who survives us. So if we have that brother that, that shady brother who beats our siblings to court and says, I want to be the executor of this estate, then they kind of win out on that. And then if there is no will, we're looking to California rules as to who is going to get what. Usually it goes to spouse, kids, but so there is an order of priority there. And if it does go to kids, the court will basically, when the kids turn 18, they get everything. And that can be a good thing. It can be a bad thing, but we definitely have a lot of clients who say 18 it's a little too soon. But, and then in the next slide, we've got, what is a trust? So a trust is, in that first bullet point, it looks a lot like the previous one. It's a document describing who gets your assets that are held in the name of your trust when you're no longer around. So the difference is that we have to actively fund your trust. So we take your house and we put that into the name of your trust. We bank accounts, investments, we are putting it in, we're retitling accounts into the name of your trust, or we are naming your trust as a beneficiary on some of these accounts, but that way your trust can govern these assets. So that's kind of the big difference there. With your trust, it's kind of like, I like to think of it as like a business. So it's your own little business. You are the documents, the trust document is the governing document. We say who's going to take control over my stuff, who is, and who I want it to go to. So I've got 3 little girls, and if something happened to me today, I don't want my kids getting anything right away. And I potentially want to hold on to it until they're 35. I mean, my oldest is kind of like, she wants to buy everything, anything and everything. So I'd probably hold it for her until she's 65. But I can do that under the terms of my trust. I can lay that out and I can say, I don't want her to get it until maybe she's 35. But until then, we're not in court. So if something did happen to me and I say, I don't want my kids to get anything until they're 35, the trustee can help them manage it. So they're not going to have like a blank check to just buy whatever they want to buy. They have a little bit of management there, but it's still outside of court.
If I'm not aware of it, you train me not to.
I'll be in my room. If you need me, just knock.
I think the sound is on someone's. Okay.
I wasn't sure if there was a question. Okay, anyways, let's see. And then that's what I mean by we can control how the property passes on and make sure that it's in a beneficial way. So my 18-year-old is not going to get it right away. She can have it there available to her for school, like if she needs it for tuition, room and board, any medical bills, anything like that. She can have access to it, but we have a trustee that we've named in our document to help her manage her inheritance until she reaches a certain age.
That's a great idea, because I feel like most young people, if given a lot of money, are just going to blow through it right away. So that's a really nice way to kind of prevent that from happening.
Absolutely, absolutely. And then there's potential tax advantages when somebody inherits assets. Really, primarily, we're talking about mom and dad's home. If they inherit through the trust, they do get what's called a step up in basis if it's inherited through the trust. So, say mom and dad bought property in the 70s for 100,000. If mom and dad pass and the new value is $1 million and the kids sell it right after they pass, the kids are paying zero capital gains tax because the new basis is as of date of death. So it kind of resets and we're not paying any capital gains on mom and dad's house. So that's huge.
For sure. That's awesome.
Yeah, absolutely. So on that next slide, so kind of rounding out an estate plan, we've got the trust and the will. Both of those kind of come into play after we've passed, but powers of attorney are effective during that odd limbo stage where, if somebody's ever incapacitated. So if, when we're younger, we think car accident and somebody's in a coma, or later in life, there's Alzheimer's, dementia, and anything like that, basically where we are still around, but can't make decisions for ourselves. So we've got, it's a legal document that gives somebody that you name the power to make decisions for you, medical decisions and financial decisions. So you can give your agent as broad authority as you like, or it can be very limited. You can only deal with this, you can only deal with my house, or you can deal with anything and everything that I have. So, and then you can use powers of attorney. So if we're using a power of attorney for, say, we're selling somebody's home because they can't live there, they're going to move to a nursing facility and they need the money for that, then the power of attorney can sell. It's just usually we want it to be really specific. Escrow, I should say, wants it to be very specific to the home. But if if we're just kind of getting something in place so that if an emergency arises in the future, then we want to just make sure that it's all encompassing and it's broad enough to help take care of our family member if they ever need it in the future. So in the next slide, we'll talk about what's probate. So what is probate? Probate is a court supervised process where the court will decide who gets what and who's going to see it through. And then, like we said earlier, all wills go through probate. To kind of back up a little bit, a lot of people ask, what is an estate? An estate is just everything that you have in your personal name. Anything in your personal name is part of your estate. And then the trigger to get into probate is you own property with a gross value of over $166,250. So even if you own a home, like let's say your home is $500,000, you've got a mortgage of $400,000 on that home. We're not looking at the $100,000 equity that you have in that home. We're looking at the $500,000 value to determine if you're going into probate court or not. So, and Destiny, you can back me up on this. I'm pretty sure you can't get anything for under $166,250, right?
Okay, there's some really cute mobile homes, all right? Santee Highlands, let's not just cut them out, all right? 55 and up community, it's great.
I mean, I'm sure it's great, but it's limited.
Very limited, yes. And you do have to be above a certain age limit to live there. So, but yeah, it is very challenging. And that's why it's so important for people to kind of talk to you for the most part, because again, it's like if you own property and you don't plan accordingly and you don't know these little things about, probate in California, then unfortunately you're missing out and it's going to make things a lot more complicated, but I'll let you get back to that part.
So Exactly right. That's exactly what probate will, is expensive, it's burdensome, it's time consuming, and it's public. So your whole family drama, your contact information, everything is available to the public.
Yeah.
And when I say it's expensive, attorney's fees, if the family hires an attorney to take it through probate, attorney's fees are actually set by statute. And it's based on the gross value of the estate. So just to kind of drive it home, if mom and dad only owned a $700,000 home, the legal fees on probate is going to be $17,000 right off the top. And so 17,000 to the attorney, approximately 2,000 to the court for filing fees, and everything that goes into that. And then the executor also is entitled to another 17,000 right off the bat. So if we've come across a lot of clients who say, I don't have that much equity in this house, is it worth it for me to go through this? But I really want to keep mom and dad's house. So it potentially becomes a balance as to, I want to hold on to it for sentimental, for the memories, but I can't afford to actually do it. So they potentially lose mom and dad's house that they wanted to keep.
Yeah, that's super, super sad. I mean, but that's why real estate planning is so crucial, especially, kind of understanding what the costs are up front. It's avoidable, I feel like, some of the more complex situations, but then again, you never know if an accident will happen. So I'm just re-emphasizing how important it is to kind of cover your bases before it ends up, accidents happen. So
absolutely. So other than it being expensive, it takes a long time. In San Diego, a simple probate matter, so even if it's just kids from a single marriage or the first marriage, and then we're just dealing with a primary home, the whole probate process can take anywhere between 18 months to 2 years. And that's saying that nobody's fighting. So, nobody's trying to say that this house should sell for more or I should get more or anything like that. That's just the statutory, where we have a lot of statutory waiting periods that happen during probate. And then, that is pretty terrible. 18 months to 2 years is pretty terrible, but at least we're a little bit better than LA County, who's going about 3 years for probate.
Wow.
So I guess we have a little bit of a leg up, a little.
Yeah. And it's interesting that you say that. I just wanted to kind of give a real world example. So the last probate that I did, it was interesting because they were telling me about two aunts that were also fighting. There was a father that passed away, and essentially he had left everything. The chief executor was his son, but the two aunties were feeling very much entitled to some of the estate, and so they basically fought them. And it took up half a year until, the court finally decided that they are the full, they have full authority, or at least Chris did. And it was very, very interesting to hear their story of, having to go back and forth with the attorneys and everything, and, just how stressful that is. Hopefully you guys have good relationships with people in your family, because that's when all the dirty laundry ends up airing out, right?
Oh yes. We hear all the stories afterwards, and when people think that they deserve more because I had a relationship with this person and nobody else in the family spoke to her, and so I should have everything. And it's like, that's not how the probate code works.
Yeah.
So the very first hearing, after the petition is filed, the very first hearing isn't until about 4 to 6 months out. So, the family is grieving. We're trying to get stuff together. We find an attorney that we trust to help us through this process, where a lot of families are at least a month or two out after the decedent has passed. And then, once the petition is put together and filed, we're still not going to get anybody appointed for at least 4 to 6 months after that. So you're going without So nobody has authority to do anything on behalf of the decedent for maybe 6 months. And that just means that we can't access their bank accounts to pay a mortgage, if there is a mortgage. So a lot of families are like, what do we do about the mortgage company? What do we do about homeowners insurance that is potentially coming to an end, and we have to figure something out? There's just a lot that's up in the air, and nobody is willing to talk to you unless they have court documents that say, I can talk with you. So it's a long time to just not be able to do anything. So that we want to avoid probate at all costs. And then on the next slide, we've got our trust administration. So to compare a probate process with the trust administration, this is what happens when somebody passes away and their assets are actually held in their trust. Then when somebody passes away, their successor trustee just steps right in, says, I am the successor trustee. I'm taking control over everything. They marshal all of the assets, is what we call it. And then they will, they have to send out notices to all the beneficiaries. So there are statutory requirements that do have to happen, but all of this happens outside of court. So as long as the relationship is good, everybody's out of court and we're just kind of checking off the boxes and just kind of dealing with stuff within the family. The trustee can, we would file a deed with the county that says we've got a new trustee, and they can move forward with selling the house almost immediately. So we don't have to worry about the mortgage incurring any penalties or any interest because we can't pay it. I mean, potentially there might be while, the house is getting ready for sale during the escrow process, but it's not the same as if we were in probate, just waiting for a judge to give us an okay. And then if the successor trustee decides to hire an attorney to help them through the process, it's like a third of probate, of the legal fees in probate court. So, if it's complicated and the family wants to kind of go back and forth on who gets what and argue about anything, then of course it's going to add to the legal fees a little bit. But if everything is just routine, potentially $5,000 to $7,000 to get through the entire process.
And just out of curiosity, what's one of the longer probates that you've had to deal with, or more complicated family matters?
We had one that was about 10 years.
10?
Yeah.
Well, just a decade of your life? Like what? Oh my God.
Yeah. It was amazing. It's because he had royalties that were coming in, and we just couldn't close it. So we just kept it going, and so that is kind of a unique situation. We had one where the beneficiaries were fighting, and that probably lasted about 7 years. So they fought until there was like no money.
Wow.
Yeah. And then we had another one in LA that was the total estate was about $60 million, and the siblings just could not agree as to who would get what. One tried to get mom to cut out her sister, so it was only going to be split 50-50, and of course that didn't go over very well. So that was a long probate process too, as to trying to get her fair share in mom and dad's estate. So
that's so crazy. And it's interesting because I've always been so fascinated by family dynamics, right? I grew up essentially as an only child. So to hear that siblings would just, become so cutthroat against one another. I mean, I'm sure you see it all the time, but that's so fascinating and sad, honestly. But I also grew up kind of poor, so I guess it didn't really affect me that much. But anyways,
it makes it easier, but
yeah.
But still, you're right. I mean, if there's stuff that mom and dad had that maybe, I want that and your sibling wants it too. So how do we split this one item?
That actually sounds just like Freddie. Freddie was telling me something about him and his sister squabbling over some very important inherited mirror. Um, and it's just interesting though to hear that. I mean, obviously they have a way better relationship and I think things will be fine with them, but it's very interesting to hear that on a legal scale, people will take certain things just so sideways and have it go to extremes. Like 7 years, that burns through so much money.
Mm-hmm. Oh yeah, absolutely.
Wow.
And that's kind of the sad part about it is, they just keep going as long as, if I'm pissed off enough and I have enough to pay for legal fees, I'll keep going. I'll keep going as long as I can, and
Yikes.
so I know there was actually a case that the siblings were spent about $350,000 on legal fees to fight over mom's pots and pans. I know. It's insane. I mean, that was not about pots and pans.
Yeah.
So
Yeah. There's always layers to families. And I feel like that's probably the psychological aspect you get to deal with. But no, sorry to interrupt, but I find it very interesting, the actual job that you do. So
absolutely. It can be entertaining at times.
oh yeah. Anyways,
so on the next slide, I've got a little chart and it's kind of like a quick reference, trusts versus wills. So for those of us who have young kids, your will is going to nominate your guardian. That just means if something happens to me and my child is not yet 18, who do I trust to take care of my child and to handle his or her finances? Your trust does not do that. It's solely in your will. With your trust, it's usually not contested in court. They do have an ability to bring this in court. If they have, if they don't like the gift that they received, they could potentially challenge that in court. Under your will, it is more likely that they're going to challenge it if they will, because your wills are already in court. So we're already here. I might as well tell you my grievances, right? A trust stays out of probate court. A will is always in probate court. Your trust can control the inheritance and your will cannot. So it's just everything to my kids basically when they're at least 18. So if they're of legal age, they get everything. Your trust is effective as soon as you sign it. And your will is, I guess technically it's effective, but it doesn't do anything until you are no longer around. So it only takes effect when you pass. Both can be changed, so you can amend anything. If somebody pisses you off at Thanksgiving, you just take them right out of your trust. No issues there. Your trust is a private document, stays within the family. Wills are public record. Trust has no probate fees, and the wills, they do have the statutory probate fees. So in the next slide, we've got our misconceptions. So there's a lot of people who, they think that a trust is, it's going to protect my assets from creditors. So they, if I put my stuff in this trust, and I have somebody coming for me for money, it's not going to protect you. A revocable trust, which is what most people have, does not offer any creditor protection. And the reason is that a revocable trust, we can do anything we want with it. So we treat it just like we do our assets now. The only type of trust that would give us creditor protection is an irrevocable trust. But an irrevocable trust takes away our control. So we can't sell the property. We can't just take it out of the trust. We can't give it to anybody that's not already in the trust. We basically just already gave it during our lifetimes. And that's why a creditor can't collect against assets in an irrevocable trust. And then this one comes up a lot. So I've had quite a few probates where they didn't create anything. And then the family will come and say, well, you know, none of the cousins ever spoke to her, and she was the only one. I mean, I was the only one that spoke to her. She came over to my house on the holidays. We always had dinner together, so I should get everything. That's not how it works. And then we have another one where it was, he didn't know his dad. He didn't have a relationship with his dad, so his dad's side shouldn't get anything. That's not the case. If you don't put anything into place, the court is going to look at the letter of the law. It's going to be black and white for them. So they're going to say, you don't have a will in place, I will split everything. If you don't have a surviving spouse and you don't have kids, I will split it half between your mom's side, half is going to your dad's side. And if you can't find anybody from one of these sides, you're going to spend a good chunk of money and a good chunk of time trying to track them down. So that is, so if you really want to write somebody out, let's put it on paper. Another common misconception, I don't have enough wealth to set up an estate plan. Like we were saying earlier, it only takes $166,250 to get us into probate court, and that's just gross value. So it's a really low threshold, and it'll get us there really fast. And then I don't own my house outright, so I don't need a trust. A lot of people think that just because they have a mortgage, they don't own the trust. That's not true. When you purchase a home, you have title, you are the owner, but the mortgage company has a lien on it. So if you ever default on the property, they will pull it back through a foreclosure, but you own your property. And then this final one, I can put my family on the deed now and achieve the same result. This you really, really have to be careful with, especially because of Prop 19 that passed it passed last year, went into effect this year. But if we are transferring property to somebody else, or we're adding somebody on, we could potentially get reassessed. So our property taxes potentially will go up, and they will have a new property value. And this recent year or two, we've seen a huge appreciation in the real estate market. Yeah. So we could be messing with property taxes, and there's no going back. So once the transfer has been made, they could potentially send a supplemental bill, and we cannot undo that anymore.
Yikes.
Yeah. And then we also have a lot of people who think that we can add our kids on as a joint tenant. And yes, it does avoid probate, but we also lose out on a really big tax benefit, which is a step up in basis, like we were talking about earlier. If the joint tenant joint tenancy with real property just means if I've got two or more people and somebody passes away, then whoever is surviving is just going to take over that property. So if we've got two people, one person passes, the survivor is just going to own 100%. Technically, yes, we did avoid probate, but our property basis is still at the purchase price. So if mom and dad put us on title and the property was purchased at 100,000, that is still our basis, even when they pass away. So potentially huge, huge tax consequences there.
Yeah.
And that pretty much wraps it up. That last slide is my contact info. So if anybody has any questions, they can reach out to me. But I will open it up for questions.
Yeah, so I definitely have a question. So I may have been clicking and letting people enter, so maybe I didn't hear this part. So is there a difference between a trust and a living trust?
They're actually synonymous. So
Okay.
when we say living trust, revocable trust, family trust, it's usually referring to the same thing.
Okay.
Mhm.
And then the irrevocable trust. So when someone decides to do that, that's more rare, correct?
Yeah.
Okay.
It's where it used to be, well, I guess kind of, it's more like advanced planning. So if we are over the estate planning, the state tax then it would be beneficial to potentially create an irrevocable trust. But right now that only applies to those who have over 23.4 million in assets. And then potentially we'll be going down to about 12 million for married couples next year.
Okay.
So
And then, so typically with the expense of creating a revocable trust, is that the same as the percentage of the probate cost, or is that different?
So our firm does a flat fee. There's firms out there who charge hourly and flat fee. Our firm charges a flat fee. Okay. And it's really kind of based on your family. So we get to know you and your family and see what you need. Some trusts are more complicated than others, but the base price for a married couple is about $2,000, and it potentially can go up from there just depending on what people want.
Okay. I would consider that a pretty small cost to protect your most valuable asset.
Yeah. Considering the alternative with probate would be much, much higher.
Absolutely. Absolutely. And then, so that kind of touches on the question that I already had, which everything encompasses this, but like, why would you want to use an attorney versus trying to do it on your own? It's really complicated. It's really difficult and really challenging. And the reason why I'm bringing this up is because my current clients that are selling over in Rancho San Diego, they accomplished quite a bit on their own. They were able to, get the full authority from the court, but they definitely skipped a bunch of steps, as you and I talked about with them. And that was kind of, it's interesting because we had already scheduled this, and then I came across their situation, and it just fits perfectly into all of this, because if you do try to do it on your own, there's not anyone to really guide you with the paperwork. And, I think there's something where they had to put a notice out in the newspaper. Could you touch on that really quick? I think it's something where you have to alert other parties or something.
Yeah, and so that's part of the probate process. When you start the probate process, you do have to publish in a local newspaper wherever the decedent died. And that is to notify creditors and any potential heirs. Really, we're just notifying. It's primarily for creditors, but it is a requirement of probate.
Yeah, and those are just little things like that most people will skip because they just don't know. There's a lot that you can learn online. However, having a licensed like real estate attorney that does this all the time, it's a lot easier. And then also in relation to that same situation, I know you were saying that the judge that they were assigned, that his calendar is booked out 4 months in advance. Is that pretty standard?
So he has actually been, he's kind of the longest. The other ones are give or take maybe 3 weeks earlier. So you could potentially get in about 3 weeks to a month earlier. His is booked out. He's just so busy that he books out really far.
And I think you and I discussed that there's no way, once you're assigned your judge, there's no just tradesies, like it just is what it is. So that's why you never know how long the process can actually be.
Exactly.
Okay. Okay. And then I think I had one more question. So are there any typical mistakes that you see executors make that hopefully the people in this can avoid?
Yeah, so I mean, with executors, we have people that start the probate process. We've got people who couldn't get appointed. We've had a gal who was just trying to get herself appointed for about a year, and she couldn't figure out what she needed to get done, and then they eventually foreclosed. So she was a year into the process of trying to get herself appointed. So trying to get through step one. And then the mortgage company said, I'm done waiting. I have to sell it. So they foreclosed on it.
Wow.
So yeah. And then we have executors who, again, think that, they're like, oh, the family said they don't want anything to do with this. So, everything's just going to go to me. Well, it's like, well, if you're in probate court and these other beneficiaries just say, all they have to do is say, yeah, I'm here, I'll get my cut, then they do, it's easier for them to just take it and accept what the court is saying you're entitled to, and they'll take it, and that's, there's kind of a lot of stuff that needs to happen in that amount of time, and there's a lot that can't be undone. With the trust administration, usually it is more straightforward. However, we have clients who want to make distributions too early. So, you get the money really fast and then you're like, okay, let's just make these distributions. Well, don't forget, you've got creditors that you potentially need to pay out. You have taxes that have to be filed for the decedent and for the trust. You've got potential costs that now, how are you going to claw it back from the beneficiaries? Now you're going to pay out of pocket, and the trustee is going to lose out on this money because you can't claw it back.
Yeah.
And then, so we have people like on one end of the spectrum who try to distribute everything really fast and they're left with nothing because they forgot about all the expenses. And then we have people who are on the other end of the spectrum and they hold it for about 11 years. And they are in a whole new world of problems because, if they sell mom and dad's home that was sitting in the trust for 11 years, they owe a ton of taxes on the appreciation from that time.
Yeah.
Or, they hold it for a long time and a beneficiary dies, and now we're in probate for the beneficiary.
Okay.
So we
Wow.
may have avoided probate for mom and dad, but now one of your siblings is going to go through probate.
That's so crazy. I mean, this is why real estate planning is so key, so that you can avoid some of these pitfalls, which obviously a lot of people do fall into. So, but yeah, Kathy, Deb, Ben, Frankie, anyone have any questions?
Yeah, I actually have two questions. So the first question is, and I wasn't able to join in on time. I was having some issues, but oh god, now I went blank. What was my question? I had two questions. Oh my goodness. Oh yeah. Okay. The first question is, how many? Is there any any recommended number of successor trustees that you recommend are put into the trust? So my husband and I were married, and obviously he will be the co-trustee. But how many successor trustees do you typically recommend that there are? I would imagine more than one, right?
Yeah, so it's really, that's kind of a personal thing. So if you are only comfortable with one other person, then that's perfectly fine too. If we have a bigger family or family and friends network that we trust to serve in this role, I like to have two as a backup. But if we have one, that's great. That, we usually include in our trust document that the beneficiaries can appoint somebody else. So we don't necessarily end up in court if our one backup just doesn't work out. Our beneficiaries can choose.
Okay, and then my second question to that was, if we were to do a trust, you mentioned something that interesting, how when you add someone on the deed, it could potentially cause a tax implication, right? So when you create a trust and move the real estate into the trust, would that also cause a tax implication at the time that you do the trust, or no?
Good question. That's a good question. No. So as long as it's done right, so the appropriate exemptions are done right, the appropriate documents that are filed with the deed. So, there's documents that also go to the assessor's office, the assessors who deals with property taxes. It will not, your property taxes will not be affected because there would be no change in ownership. We're just saying it's still mine. It's just going into my family trust.
Got it. Perfect. Thank you.
Yeah, of course. And then along those lines, because a lot of people do like to ask whether their mortgage is going to be affected by a transfer into their trust, and it does not.
That's good to know. And then Rachel has a question as well. Rach.
Hi, good evening.
Hey.
I have a question. So I have a family trust, but what if I want to make updates to my trust? Do I have to go back to the original attorney for that, or could I come see you and your company? Because I definitely, there are some changes I want to make. There's some different assets I want to put in. I just bought a home last year and it's not even in my trust yet, and it stresses me out every day.
Right. Yeah. No, they are your documents and you can go wherever you'd like. You do not have to go back to the same attorney.
Okay.
We'd love to sit down and chat with you about, what changes and whatnot. So absolutely. You can go
Okay.
anywhere you'd like.
Okay, awesome. I'll be
Yeah.
calling you.
Awesome.
Cool,
Thank
cool.
you.
I have a follow-up question to that because Rachel, that was a really good question. But so like if you were to add additional assets, because I wasn't aware, do you need to specifically name every asset that you want into the trust, or is there a blanket trust that you can just create that whatever asset you acquire in the future, it could just automatically be in there without having to make an amendment?
Right. Wow, Destiny, these are all like great questions. Everybody's so awesome.
I love my people.
Right? I know. No, so we do recommend that everything be an asset of your trust. So your home, it does have to be a deed. If you buy a new home in the future, we want to, just do a deed that puts it back into your trust. You do not have to amend your trust just because you have a new property. You would amend your trust if you are changing the beneficiaries. So if we have, where our family is growing, so we're saying everything is going to go equally among my kids. And then we get to a point where I'm not going to have any more kids. I know I'm 100% sure I will not be having any more children. Then we can close that class, and that would be an amendment. If we have our successor trustee, but we want to add to that, or we want to change that, or they're no longer around, that would be amendment to your trust, but not necessarily your assets. So we open a new account, new bank account, new investment account. That is not, you don't need to amend your trust for that. And then, we just want either your trust to be the owner or the trust to be a beneficiary for, say, bank accounts, investment accounts, retirement, life insurance. That's, we normally recommend your trust as a beneficiary.
Cool. So did anyone else have any additional questions for Caroline? This has been super informative for me. No? Okay, you guys. Well, thank you so much, Caroline, for coming on and being so descriptive. Again, like, this is not typically a topic people enjoy discussing, but it's so critical. I mean, again, it's like once you make the commitment of purchasing real estate, like, you do want to consider your legacy. And again, it's like, obviously people think it's as easy as just, throwing it into a will, but wills are very, as I've come to learn, not that useful. So you got to do a little bit more. But yeah, thank you so much. I appreciate your time, and thank you everyone for joining. Again, really great questions. And yeah, I guess I'll catch you guys later.
Awesome.
Thank you.
Thanks, ladies.
All right, bye you guys.
Bye.
Okay, I'm gonna